We have three excellent speakers this evening talking about three very interesting topics. There's Emmett Coldrick, Darrell Kennard, and Andrea Skeoch. There will be a question and answer session afterwards, but if you have any questions or points you want to make, please use the chat function to do that rather than expecting to be able to speak. So type out in the chat function whatever it is that troubles you or you want to raise. And we're going to start with Emmett Coldrick, who was called to the bar in 2004 and practices at Quadrant Chambers in London. His practice is largely in the sale of goods and shipping work, especially disputes under charter parties and bills of lading. And he's going to talk about the decision in the Sea Challenger, which we probably all know about. It raised a whole slew of questions, including implicit pre-contract representations, the relevance of reservations of rights to questions of affirmation, where damages in lieu of rescission should be awarded, and the consequence of an ineffective rescission and the scope of an intermediate broker's authority. So a good field to be traversing at the moment. So over to Emmett.
Thanks very much, Bruce. It is, I think, a testament to the enduring popularity of arbitration, especially LMAA arbitration, that trials in the English High Court of charter party disputes are something of a rarity. The 2019 edition of the Lloyd's Law Reports includes only 3 such cases, the 2020 edition 1. When they do come along, such trials frequently shed light on a point or two of interest to shipping practitioners, or less often a point of wider interest. The Sea Challenger, in which Mr. Justice Foxton handed down judgment in December, is then a rare case indeed. The judgment followed a 10-day commercial court trial of a charter party dispute, and the case threw up not just many points of interest to shipping practitioners, but several points of wider significance. The judgment runs to 114 pages, and it's not possible to do full justice to it in a 20-minute talk like this. The best that I can do is to touch on 4 of the points that arose, 2 of quite narrow interest to those who deal with charter party disputes, and 2 of wider interest. But first, the facts. The case, which generated so many points of interest, was of all things a speed and consumption dispute. SK Shipping were the owners of the Sea Challenger, an oil tanker. They'd been chartering her out on the spot market through consecutive voyage charters. But in late 2016, they decided on a change of strategy and to charter her out on a long-term period basis instead. To that end, they circulated vessel details, including figures for speed and consumption, to the market. A potential charterer, CMTC, expressed interest, negotiations followed, and a 2-year time charter was agreed in December 2016. The charterers soon noticed that the vessel was consuming bunkers at an excessive rate. They raised this and repeatedly protested, alleging that the owners had misdescribed the speed and consumption characteristics of the ship. All the while, the charterers expressly reserved their rights, but they continued to give employment orders and initially to pay hire. By October 2017, matters had come to a head. The charterers ceased to pay hire and were pressing for the ship to be dry docked. The owners served an anti-technicality notice threatening withdrawal. And finally, on the 19th of October, the charterers purported to rescind the charter party for misrepresentation, alternatively to terminate it for repudiatory breach. For their part, the owners purported to terminate the next day on the basis that the charterer's message was itself a renunciation of the charter party. Owners commenced proceedings, claiming unpaid hire and damages, and the charterers defended on the basis that the owners had misdescribed the vessel's speed and consumption performance, and that the charter party had been lawfully rescinded. That takes me to the first of the 4 points. It's fair to say that this is a point of quite narrow interest to those who deal with charter party matters. Where a ship owner in pre-fixture negotiations puts forward figures for the vessel's speed and consumption performance, what precisely is being represented? Now, anyone who might hope for a definitive answer to that question would be sure to be disappointed. English law approaches interpretation in accordance with, as Lord Hoffman put it in ICS in West Bromwich, the common sense principles by which any serious utterance would be interpreted in ordinary life. That's the case whether the task at hand is the construction of a contract or the interpretation of an email with a view to ascertaining what, if anything, was represented by it. So there can be no law of vessel performance representations as such. What, if anything, is being represented in any given case will always depend on precisely what was said and in what particular context. Nevertheless, the common law, of course, proceeds by analogy from previously decided cases. So it's always of interest to see how a judge approached a matter and what he or she decided. The position of the owners in the Sea Challenger was that their statements about the vessel's speed and consumption did not represent anything aside from the terms on which they were willing to contract. In other words, their statements did not assert any fact about the vessel at all, but were rather statements in the nature of proposals about potential contract terms, or in the legal terminology, words in the nature of an offer to contract or an invitation to treat. Now that might seem a rather extreme and ambitious position, and so it proved to be. The judge rejected it. But an argument along those lines had been accepted by Mr. Justice Hobhouse in a 1983 case called the Larissa. In the Larissa, the relevant pre-contractual communication by the owner's broker had stated performance, owners to guarantee 14.6 knots in max Beaufort scale number 5, consumption 42 long tons HVF. Mr. Justice Hobhouse held, and I quote, "These words on their ordinary meaning are words of contractual offer relating to a contractual term. The contractual term is a term of obligation, not a term of representation. As a matter of law, I hold that the correct interpretation of these words in the telex is that they are words of obligation, not words of representation." What then made Mr. Justice Foxton reach the contrary conclusion about the communications that he was considering? Well, what had been said was very different to what had been said in the Larissa. In the Larissa, the relevant words began performance, owners to guarantee 14.6 knots. In the Sea Challenger, by contrast, the figures that were given were expressly stated to be based on average of last 3 voyages, whereas in fact they were based on other earlier data, which were not reasonably consistent with the most recent performance of the ship. So the Charterers established the foundations of a misrepresentation defence and counterclaim, but they were not content to rest their case on the falsity of the express representation that the speed and consumption figures were based on the vessel's last 3 voyages. Why was that? The answer is probably that the Charterers were attempting to maximise their chances of achieving the result they sought, a decision upholding their purported rescission of the Charter Party on grounds of misrepresentation. In the case of a claim for breach of contract, the aim of the remedy afforded by English law is to hold the parties to their word. The innocent party is to be put in the position in which it would have been if the contract had been performed in accordance with its terms. By contrast, the remedy that English law affords in cases of misrepresentation has a rather different goal. It's not to hold the party concerned to its word, in the sense of putting the parties in the position they would have been in if the representation had been true. It is, rather, to put the innocent party in the position it would have been in if the false representation had not been made in the first place. So the best that the Charterers could hope to achieve in the Sea Challenger was thus to persuade the court that they would not have entered into the Charter Party if the false representations had not been made to them. Their chances of persuading the court of that, of proving inducement, would be improved if it could be shown that the owners had made not just a false express representation about what the figures were based on, but a further implicit representation that the owners expected the vessel to achieve substantially the stated performance in the future and had reasonable grounds for that expectation, when in fact they did not. The court rejected the Charterers' argument that such a representation about the future was implicit. The future position might depend on a number of factors, including when the vessel entered the chartered service, which might be some time after the representation was made, and the length of any port stays and fouling over that period. There's also the inherent uncertainty as to what the words "in the future" might mean in circumstances in which deterioration of performance over time was likely and the charter party was for 2 years. That brings me on then to the second point, which concerns the principles applicable to rescission for misrepresentation, which is clearly a matter of much wider interest. The legal position as regards rescission of contract for misrepresentation is very different to that regarding termination of a contract for breach. Termination for breach is a true self-help remedy in the sense that if, as a matter of law, the remedy of termination for a breach is available on the facts, the innocent party has a right to avail itself of that remedy and can do so without the involvement of a court or tribunal. All the party needs to do is to communicate to the other party that he's elected to terminate. In cases of a rescission for misrepresentation, by contrast, the innocent party is in a much more precarious position. An actionable misrepresentation may make the remedy of rescission available in principle, but as Section 2.2 of the Misrepresentation Act 1967 makes clear, absent fraud, it's ultimately for the court or tribunal to decide whether to grant that remedy or to award damages instead. The issue arose in the Sea Challenger of whether, when deciding whether to award damages in lieu of rescission, the court should take into account the fact that if it were to take that course and declare the contract to have subsisted, the consequence would be that the representee would be exposed to a claim for damages for a repudiatory breach. Let me unpack that a bit. I mean, there had been a false representation, and the representee, the charterers, had purported to rescind. If the court were to award damages in lieu of rescission, the consequence would be that the charter party would be declared to have been subsisting, not rescinded. But the charterers had purported to rescind, and in doing so, had walked away from the contract and clearly evinced an intention not to perform it. Thus, the owners, who'd been guilty of misrepresentation, would have been within their rights to terminate for repudiatory breach and to claim very substantial damages. The question then was, when deciding whether to uphold the purported rescission or to award damages instead, should the court take into account the effect on the charterers of denying rescission, which would be that they were in repudiatory breach and liable to the owners in damages accordingly? Perhaps surprisingly, there was an absence of authority directly on this point. The court decided that it was not a relevant consideration that awarding damages in lieu of rescission would expose the charterers to a large damages claim for repudiatory breach. It reasoned that while Section 2.2 said that the court was to have regard to the loss that would be caused by the misrepresentation if the contract were upheld, as well as to the loss that rescission would cause to the party which had been guilty of the misrepresentation, it made no mention of having regard to the wider effect on the representee of refusing rescission. Mr. Justice Foxton's judgment was, as he acknowledged, obiter on this point, not least because, as I'll come on to in a moment, he had decided that the charterers had affirmed the contract and that as such, any right of rescission they might otherwise have had been lost. But the upshot of this reasoning, were it to be followed, and I expect it would be, is that representees considering rescission would be well advised to exercise very great caution. As the judge said, although retrospective in its effect when granted, a party who requires the court's support before any rescission becomes effective acts at its peril if it irrevocably commits itself in anticipation of that exercise. Point 3, affirmation. This is also a point of wider commercial interest. The charterers had repeatedly said that they reserved their rights, but they'd also continued to give employment orders and to demand performance from the owners. In those circumstances, had they affirmed the charter party, or did their express reservations of rights preserve any right to rescind? Given how commonplace express reservations of rights are, it was again perhaps surprising that there was a lack of authority directly on the point, at least outside the context of landlord and tenant law and insurance law. The view expressed by Dominic O'Sullivan QC of the Australian Bar in the Law of Rescission was that the insurance line of authority was to be preferred, and that a party entitled to rescind should always be able to protect himself against the risk of unintentional affirmation by expressly reserving the right to rescind. On the other hand, as the judge observed, are there not some occasions when, to paraphrase a dictum of Mr. Justice Long Innes in an earlier case, a man who eats his cake will find it gone, none the less so because he ate it without prejudice. The court concluded that while a reservation of rights will often have the effect of preventing subsequent conduct constituting an election, this is not an invariable rule. The issue of whether there has been an election requires the court or tribunal to have regard to all the material, including any reservations which have been communicated. Where conduct is consistent with the reservation of a right to rescind, but also consistent with the continuation of the contract, then an express reservation will preclude the making of an election. This is likely to be the case where there's a reservation of rights accompanying the exercise of a right to obtain relevant information, or where a party is performing its own obligations while assessing the position. However, where a party makes an unconditional demand of substantial contractual performance of a kind which will lead the counterparty or third parties to alter their positions in significant respects, such conduct may be wholly incompatible with the reservation of some kind of rights, even if the party demanding performance purports at the same time to reserve them. On the facts of the C Challenger, the court concluded that by July 2017, if not earlier, the charterers believed and were aware that they had a sufficient justification for believing that the consumption of the vessel had been misdescribed. As the judge put it, they had moved beyond suspicion to a state of knowledge. While they continued to seek documents from the owners, that was not for the purpose of reaching a decision as to whether the vessel's consumption had been misdescribed, but was rather to strengthen their case in relation to the misdescription they were already convinced had been made. In those circumstances, the court concluded that the conduct of subchartering the vessel and ordering it on a cargo-carrying voyage was so inherently affirmatory that it was incompatible with an attempt to reserve a right to rescind. Thus, in a loose sense, one might say that the charterer's actions in demanding substantive performance were found to speak louder than their words of reservation of rights. But ultimately what was decided is that the right to elect between affirmation and rescission has hard legal limits, which a party can push back only so far by saying it reserves its rights. Express reservations of rights are a relevant consideration, but once the party concerned has obtained sufficient knowledge and has had a reasonable opportunity to decide what to do, it must use or lose its right of rescission, or at least tread very carefully before demanding anything of its contractual counterparty. It might well be inferred from continuing express reservations of rights that the party concerned still wishes to continue to reserve its right to rescind, notwithstanding that for the time being it's still performing the contract and still seeking performance from its counterparty. But the law may step in nevertheless and say in effect that you knew enough and had time enough to decide to rescind, and that insisting on carrying on with the contract beyond that point entailed, as a matter of law, giving up your right of rescission. That brings me to the last point, which I'll take shortly. In the C Challenger, the fixture recap named the charterer as company to be nominated and guaranteed by CMTC. A company so nominated was the charterer under the charter party. But the owners also wished to claim against CMTC itself. No formal guarantee had been provided, however. There was only the fixture recap email, stating as I've just quoted, and some other messages around the time mentioning, similarly briefly, that CMTC was to guarantee performance. An issue arose as to whether that was enough to satisfy the requirements of Section 4 of the Statute of Frauds, 1677, which provides in effect that a guarantee is unenforceable unless A, it's in writing or evidenced in writing, and B, the guarantee or written evidence of it is signed by the guarantor or by a person authorized by the guarantor. The courts have taken a rather relaxed attitude to the signature requirement, provided that the authorized by the guarantor requirement is met. It's enough, for example, to have an email referring to the guarantee, which is signed off, best regards Rob, to give an example from the C Challenger, or simply signed off with a first name or initials. The authority issue arose in the C Challenger because the brokers via whom the communications took place were intermediate brokers. CMTC contended that when sending messages, an intermediate broker is acting on behalf of the recipient of the messages, not the sender, and that as such the messages relied upon by the owners were not authorized by the guarantor as required by the Statute of Frauds. Mr. Justice Foxton rejected that contention, holding that an intermediate broker acts on behalf of the party that wishes its communication to be passed on, that is, the sender, not the recipient. The upshot is that where an email referring to a guarantee comes from a charterer's broker or an intermediate broker and contains any kind of signature, a typed name at the bottom of the email would be sufficient, the requirements of the Statute of Frauds will be satisfied, and the owner will be entitled to claim not only against the charterer, but against the party that has agreed to guarantee the charterer's performance too. I should add the caveat that the C Challenger was not a case where any error or wrongdoing was asserted on the part of the brokers. It remains to be seen how the courts would deal with such a case, but Mr. Justice Foxton gave a strong hint that, as I think must be right, a purported guarantee will not be enforceable unless the guarantor has actually agreed to give the guarantee and for that to be communicated to the ship owner. So thank you for listening. There's much more that's of interest in the C Challenger than I've managed to touch on. I suspect it's a case that many of us will come across in practice in the coming years. So with that, I'll hand back to Bruce.
Thank you very much, Emmett. That was brilliant. And I must say, I like the last part, the question of the role of the intermediate broker, not least because it's a problem that does come up quite a lot. On whose behalf is an intermediate broker acting? So that was but a very good traverse of all the issues or major issues in that case. Thank you very much. Now we move to Daryl Kennard, who is a partner in the Marine Trade and Energy Department of Pennington's Manchester Cooper. He's an unusual creature in the sense that he is one of the very few shipping lawyers who specializes in both wet and dry work. And he acted for the successful appellants in a case called the Thai Prize, which is about the words apparent good order and condition, and what they mean and who's making any representations by them. So over to Daryl to tell us about the Thai Prize, please.
Thank you, Bruce. So I'm going to talk about the Thai Prize, as Bruce said, a case that came up before the Court of Appeal. So I have 20 minutes, so a quick canter through. A familiar landscape. Soybeans arrive in China. There's some evidence of damage, arguments about inherent vice, etc. In this case, the perhaps slightly unusual factor was that at least some of the damage were blackened beans, which could only be ascribed to silo burn at the load port where the beans have been burnt whilst in the silo. And so, of course, that's pre-shipment damage. Normal story, Congem bills of lading incorporating the Law and Jurisdiction Clause and the Voyage Charter, which was, of course, London arbitration English law. Nevertheless, claims brought in China are in breach of the bill of lading obligations. Chinese courts considers all of the evidence and comes to what sometimes feels like the inevitable conclusion that the head owners are liable, and there was a liability they incurred under a Chinese judgment for $1 million. The head owners in turn turned around to their time charterers Noble under the ICA and claimed a contribution. The liability was apportioned 50-50 under clause 8D, and then the Noble disponent owners claimed against our clients, but they had a voyage charter. So there was no ICA, and the arbitration was the arbitration between the disponent owners and the charterers. The crux of the case, initially they put the Noble put forward 3 bases for claims, but only one of them followed through, was successful before the arbitrator and followed through into the High Court and then Court of Appeal. And it surrounded the existence of the implied indemnity in the charter, indemnifying owners against the consequences of signing inaccurate bills of lading which are presented. That it was common ground that indemnity existed, and the arbitrator held that the indemnity was engaged because the shippers were deemed to have known of the pre-shipment defective condition of the beans, no doubt because it was silo burn as opposed to just being inherent vice, and which manifested itself during the voyage. And that silo burn could not be discovered by the master on a reasonable and customary inspection on loading. And that was simply because the soya beans were loaded at such a rate with a cloud of soybean dust that the damage wasn't observable during the course of loading. And that was the customary mode of loading the cargo. So the arbitrator held that the presentation of a bill of lading stating that the goods were shipped in apparent good order and conditioned contained a statement that the shippers knew to be inaccurate. So we'll move on to the Court of Appeal decision. The owners, it was a key plank of their case that the presentation of a draft bill of lading was was 2 things. It was a representation to the master that the cargo was, to the shippers stroke charterer's knowledge, in apparent good order and condition. And it was also, as is well understood in the market anyway, an invitation to the master to sign the bills of lading as tendered upon having made his own assessment during loading. So I think the novel point was that first limb of what they said was happening when a bill of lading was tendered, that in so tendering, a representation was being made. The owners relied on the well-known cases of Kruger and Moltravan, Dawson and Adler, and Elder Dempster v. Dunn. And the owner said the arbitrator was right to hold that there is a general principle that where the contract required the master to sign a bill of lading as presented, in other words, it contained an express obligation to sign as presented, and the charterer, or a person for whom the charterer is responsible, here the shipper, presents an inaccurate bill, the charterer must be responsible for the consequences that follow. And since the charter party here required the master to sign the bills of lading as presented, the owners contended for a right of indemnity insofar as the bills presented were in fact inaccurate. The charterer's arguments were as follows. They said it was long established that statements in a bill of lading as to the apparent good order and condition of the cargo are representations made by the master based on his own assessment of the cargo. So it's not a representation by the shipper, but it's in fact a representation by the master. The presentation, the act of presenting a draft bill of lading, contains no representation by the shipper as to the apparent good order and condition. And this is particularly so where the Hague and Hague Visby rules apply by virtue of Article 3 Rule 3 and 3 Rule 5. The Court of Appeal analysed the decision of the arbitrator, and the analysis can be split into 5 main broad topics: the meaning of apparent good order and condition, whether the bill of lading was accurate, the tender of the draft bills and the implications that arise from tendering, the indemnity cases and the emerging principle, and they also addressed owners' cry that this would encourage misdescriptions in bills of lading if the law was not in their favour. So, apparent good order and condition. Lord Justice Mayles highlighted the Peter de Grosse, where it was held that it means apparently, and so far as met the eye, and externally, that they were placed in good order on board the ship. He also specifically referred to Silver and Ocean steamship. In this case, the shipment was tinned Chinese eggs, and they were loaded at night in Shanghai. Some of the tins had gashes, and it was held that these would have been apparent to the eye on a reasonable examination during the course of loading. The damage was so obvious it ought to have been noted on a careful inspection. Others had pinhole perforations that were not apparent, and so the damage, the gashes was something that was apparent, and so you couldn't describe gashed tins as in good order and apparent good order and condition, but the perforated tins was not apparent. And of course, he picked up on the David Agmash-Belli. I've practiced all day to say that. The law does not cast upon the master, this is Coleman's well-known dicta, the law does not cast upon the master the role of an expert surveyor. He need not possess any greater knowledge or experience of the cargo in question than any other reasonably careful master. What he's required to do is exercise his own judgment on the appearance of the cargo being loaded. This imposes on the master a duty of relatively low order, but capable of objective valuation. So in summary, apparent good order and condition, what? It's the external condition as is apparent on a reasonable examination. Who? It's what's reasonably apparent to the master. The bills contain a representation by the master. When? At the time of shipment, not earlier. That was, of course, to address the argument that the shippers would have known about the defective nature of the cargo at an earlier time, and how on an examination which the master has or should reasonably undertake, depending on the actual circumstances. So, of course, loading is to occur in the normal way, and if environmental conditions or nature of the cargo or the manner of loading make it difficult to observe any defect, then the master won't be criticised for not having noted that. This dovetails with the Hague rules. As we know, Article 3, Rule 3 obliges the carrier to issue a bill of lading, setting out leading marks, number of packages, quantity, weight, etc., and also the apparent order and condition of the goods. But compare that obligation which is on the carrier with Article 3, Rule 5. In Article 3, Rule 5, the shipper is guaranteeing to the carrier the accuracy at the time of shipment of the marks, weight, quantity, etc. But you'll notice that he is not guaranteeing the apparent good order and condition of the cargo. That's not within his remit. That is because the statement in the bill of lading as to the apparent good order and condition is a statement that is made by the master and not by the shipper. Then Lord Justice Mayles went on to consider whether the bill was accurate. The arbitrator had found that the damage was not reasonably visible to the master during loading. This meant, Lord Justice Mayles said, that the cargo was in apparent good order and condition, even though some of it was actually damaged. That damage, though, couldn't be discovered by the master during loading. The fact the shippers would have been able to discover by reasonable means the defective condition of the beans was nothing to the point when considering whether the bill of lading itself was accurate. The issue is simply whether the cargo was in good order and condition so far as met the eye, and for this purpose, Lord Justice Mayles stressed, it's the master's eyes which count. Then Lord Justice Mayles went to consider the tender of a bill of lading. He said, everyone knows that the tender of a draft bill is an invitation to the master to sign it, having satisfied himself the cargo is in apparent good order and condition. The implication of an implied warranty is neither necessary to give the charter party business efficacy, nor so obvious as to go without saying. In other words, an implied warranty by the shipper in favour of the carrier as to the apparent good order of the condition could not be upheld because it didn't pass the test set out in Marks and Spencer's. And it also ran contrary to the Hague rules, and there was a clause paramount in the charter. So if you think about it, in fact, the master or the carrier had agreed to issue a bill of lading setting out the good order and condition of the apparent good order and condition of the cargo, and there was no corresponding warranty by the charterer going back on that point. And Lord Justice Mells also noted it runs contrary to the Nogar Marin. So the Nogar Marin, in this case, a bill of lading was issued stating wire rods in coils were shipped in apparent good order and condition, even though they were rusty on shipment. The master was negligent in failing to record rust, and such negligence broke the chain of causation between any breach by the charterers and the loss. And Lord Justice Mustel in that case said there was no implied term in the charter as to the accuracy of the tendered bills for matters not uniquely within the knowledge of the shipper. He said it was pointless because the defences under the bill of lading would have ensured there was no enhanced exposure anyway to the carriers. And if a liability arose, it arose because the master failed to do his job and properly inspect the cargo and record the apparent good order or the apparent bad order and condition of the cargo, I should say in that case. Encouragement to misdescribe. Lord Justice Mells did say at the end that it might be unfair to allow charterers who actually knew of the defective condition of the cargo to escape liability. But he said that there was no evidence or finding of actual knowledge in this case. The arbitrator only imputed knowledge. He said the Court of Appeal's role is only to determine specific points of law. The cri de coeur that the owners made throughout the case, that the outcome was unfair, was neither here nor there. It went nowhere. So takeaway points. Well, the case, of course, only arises because the Chinese court, who wrongly assumed jurisdiction, but did not absolve owners of liability on the grounds that the goods were not damaged during transit, and the actual defective condition of the cargo was not reasonably discoverable by the master upon loading. But the words shipped in apparent good order and condition in a draft bill of lading do not constitute a representation by the shippers vis-a-vis the owners. This is well known in the industry, reflected in the Hague rules. After all, it's the master's job, nobody else's, it's the master's job to record the apparent order and condition of the cargo. And the presentation of a draft bill stating that the cargo is in apparent good order and condition is nothing more than an invitation to the master to sign the bill of lading based on his own assessment. And of course, if based on his own assessment, he doesn't think they're in apparent good order and condition, he should clause the bills, i.e. put a remark on those bills. The cause of action for an indemnity for the liability that they said had incurred by reason of the bills containing inaccuracies, that was their cause of action. The difficulty was the bills were accurate, and once it was established that the bills were accurate, then the claim based on that premise failed. Any claim in misrepresentation would also have failed because there can never be any reliance by the master on what's contained in the bills, because of course it's his job to make his own assessment. So short summary: who, the master, when, upon shipment, what, external condition, how, reasonable and customary inspection. Thank you.
Well, thank you very much. Thank you very much, Daryl. It's very interesting. This may be one of those cases where the merits and the law do not entirely coincide, at least from certain points of view. Now we move on then to Andrea Skeoch, who is a senior solicitor with the North of England P&I Association in the F&D department there. She has 24 years of shipping disputes experience, and she's going to talk about something that is absolutely bang up to date, which is the legal fallout of the COVID pandemic. Andrea.
Thank you. Thanks, Bruce. COVID and the legal fallout. The purpose of this talk is not to give you the answers to the legal issues that have arisen, but to flag what those legal issues are. I understand from the LMAA that they haven't actually seen that many cases come through the arbitration system as yet, and I suspect that will change, especially given that the bulk market dry bulk rates have gone through the roof, and therefore disputes will be bigger as a result. Obviously, time will tell. But I want to go through the main type of disputes that we as a club have been seeing, and I'm sure all the other IG clubs and law firms out there are seeing the same sort of issues. As I say, I'm not going to give you what the legal answer is to these disputes. That's for the LMAA arbitrators when the cases come before them. But I can give you a broad idea of what the disputes are, the sort of issues that are arising, and the arguments that are arising. The first type of dispute is an owner's refusal to call at port. Crew changes are causing issues as well. Obviously, crew illness and the quarantine issues that flow from that, and also laytime issues and force majeure clauses in voyage charters. An owner, understandably, especially in the early days of COVID, was very reluctant to go to ports. They saw a port had COVID. I don't want to go there. I don't want to run the risk of my crew getting ill and the knock-on effects of that. So they wanted to turn around and say to a charterer, you want me to go to port A? Well, I'm not going to go. They would raise the safe port warranty, to which the charterers would say, well, what's your problem? What's the risk? You can take precautions, can't you? You can make sure the crew have appropriate protective equipment, wear masks, you can monitor who's coming on and going off the vessel and that they're taking the appropriate precautions as well. So it's not safe. So that was the two competing arguments on that. The other basis for an owner arguing that they can't go is on any relevant COVID or infectious disease clauses in the charter party. Most obvious one is probably the BIMCO Infectious Disease Clause. That provides that if in the reasonable judgment of an owner that the place he's being ordered to is an affected area, he can refuse to go. And an affected area is one where there is a risk of exposure to infectious disease and quarantine. Now, query, is there where in the world that is not an affected area? I don't think there's many places that haven't been affected by COVID in some way. But you have to look at what are the rate of infections in a particular place. I mean, obviously, a country may have COVID infections, but just as there were here in the UK, you had some areas and regions that were more prone and affected by it than others. Which port is the vessel actually going to? What are the safety procedures in place? Has the owner made a reasonable judgment? What is the actual underlying risk? And there can be issues as to whether the owner has satisfied that requirement. Problems also arise when it's not always the BIMCO Infectious Disease Clause which is incorporated into the charter. Sometimes you have other clauses. I think there was a rush by parties in the early days to roll out bespoke clauses. Some are charter friendly, some are owner friendly. Some don't give an owner the right that they want to have. And so you have to look at each of the clauses and see what they say. One of the problems that you can have is where the parties have tried to tweak the BIMCO clause. And the BIMCO clause is incorporated, but then you have amended it in the recap. And I have seen a couple of cases where the recap actually deletes that part of the BIMCO clause, which defines what an affected area is. But then you have the rest of the clause, which still refers to affected area throughout. And then you have real difficulties in working out, well, what is the scope of the owner's rights into such a clause to refuse? And obviously a charterer, he's fixed a contract, he wants the owner to go there. You have an owner refusing to go, the disputes can be quite major. I think it's fair to say that after the early days, the number of outright refusals to call at ports lessened. I think owners tended to think, well, okay, if I have to, I'll go, but I'm reserving my rights under all the other aspects of the clause. So the disputes may subsequently come depending upon what happened further down the line. Crew changes, or perhaps lack thereof. When COVID hit the world, understandably, many countries just shut up shop. They would let vessels come in to load and discharge, but they weren't going to let crew off and they weren't going to let crew on. And the effect of that was that the crew was stuck on board the vessel. Some charters have liberty to deviate clauses in the charter, but that's all well and good if there's no country which will actually permit a crew change. I mean, the BIMCO have a liberty to deviate clause to perform crew changes, but as I say, in many cases, it wasn't worth a great deal in practice. The result of that, the crew was staying on board for months on end, and in many cases in excess of a year. Now that exceeds the ITF recommended maximum length of service and exceeded the length of service provided for in crew contracts. Also, in certain jurisdictions, and Australia leaps it immediately to mind, there is a cap on the length of service permitted. And if the crew have been on board longer than that, the authorities can detain the vessel. And the vessel will not be permitted to leave unless and until the crew have been changed. And obviously, that can cause quite a lengthy delay. You can't just arrange a crew change like that. And fines can be imposed. And the question is, who's going to pay for all that? And I'm going to give you a couple of scenarios so you can see some of the types of dispute that have arisen. So one scenario, there's no liberty to deviate to change crew clause in the charter. The charterers have ordered the owners to go to port A, and the owner's en route, but en route he identifies a port where actually it is permissible to change his crew. So he approaches his charterer and say, look, I need to change the crew. Can I just deviate? Won't take very long. We'll change the crew. We'll continue the voyage. It won't be a problem. All well and good. Charterers, however, turn round and say, well, actually, no, I don't agree. I don't allow you to deviate. You're proceeding to the low port for my next fixture. I've got a laycan to meet. If you deviate, I might miss it. So no, you can't go. Or alternatively, if the vessel's fully laden, we'll turn around and say, well, actually, the cargo's needed at the destination. Bills of lading obligations, go to the low port, the discharge port. So the owner does what he's told, he goes, and then when he either gets to that port or alternatively at a subsequent port, a few voyages down the line, he is detained by the local authorities because he has exceeded the length of crew service on board. Now, the charterer inevitably puts the vessel off hire. The owner might turn round and say, well, hang on, I wanted to change my crew. I'm being detained because I haven't changed my crew. You ordered me not to do it. You charterer are responsible for this. I'm not responsible. I'm going to claim all the time and cost back from you by way of the implied indemnity. Now, who's right and who's wrong, who knows? But that's the sort of arguments we're getting. Another scenario is that this time the owner does deviate, but without the charterer's consent, or at least the owner deviates, the charterer tells him that he doesn't consent or doesn't say anything, but reserves his right. Now, owner goes to the port to change the crew. Crew change, unfortunately, takes a little bit longer than he anticipated. So he's delayed in his departure to continue the voyage. As a result of that, the charterer misses his laycan on his next fixture. Obviously, the charterer is not very happy about that, so he submits a big claim for loss of earnings under the subcharter. And it's whether the owner can claim a defence under the clause paramount, which incorporates the Hague rules. The argument that the owner typically puts forward is that, well, the reason he deviated is that there's an ITF clause in his charter which requires him to meet the ITF requirements for crew contracts, and the length of service of the crew exceeded that. And also, if he continued without changing his crew, he ran the risk of detention at another port. Therefore, it was perfectly reasonable what he did. So, he's got a defence. That's the argument. Quarantine is also a big issue. Two types of quarantine issues arise. One relates to automatic compulsory quarantine. Again, as COVID has swept the world, jurisdictions identified certain COVID hotspots where there was very high numbers of infection. And as a result, ports sort of said, if a vessel was coming from such a port within a specific period, usually about 14 days, that the vessel would automatically have to quarantine. Now, if that prior port call was prior to the owner delivering the vessel into his charter, and the vessel gets to the first load port and is quarantined, that might mean that the charterers cannot in fact validly deliver into their subcharter. So they may miss the laycan as a result of that. Or alternatively, the subcharterers don't cancel, but the NOR is found to be invalid. Bearing in mind the vessel could be sitting there for 14 days. That's quite a lot of loss of earnings because they can't tender a valid NOR. And again, you have the issue there as to whether or not an owner has a defence to that claim under the quarantine restrictions exception in the Hague rules. So again, these are all the arguments that are being brought forward, and loss of earnings claims can be quite large. So if an owner can try and avoid it, he's going to put forward those arguments because he doesn't want to have to pay a big damages claim to his charterers. The other type of quarantine claim is quarantine due to crew illness. The vessel arrives at a port and a member of the crew tests positive for COVID, or even if he doesn't test positive, is exhibiting symptoms of COVID. And the local authorities are taking a very cautious approach and will generally quarantine the vessel anyway. Now, where ultimately liability will lie will often depend upon the scope of the particular COVID clauses in the charter. Excuse me. Well, the issues that arise is, well, when and where were the crew infected? And also, what was the cause or source of the infection? Is it a result of the charterer's trading of the vessel? They've been ordering the vessel to ports where COVID was rife. Or is it as a result of the crew's failure to take proper precautions? And, they've been failing to maintain social distancing insofar as possible. They haven't been using proper protective equipment, haven't been wearing masks, or they haven't been making sure that shore personnel coming on board are wearing masks and taking appropriate steps. So you can see the competing arguments there as to who is ultimately going to be responsible for that. A lot, as I say, will depend on the COVID clause in the charter, and they can vary depending on whether it's a BIMCO clause, an amended BIMCO clause, or a bespoke clause. Laytime issues also arise, again, because of quarantine. Can the owner tender a valid NOR? And does laytime commence? We all know that most charters will have a whether in free critique or not clause in there, but a charterer will probably turn around and say, well, it wasn't a formality to get free critique and therefore it doesn't count. But you have to look at the clauses as well, and have you got a free critique clause akin to a hold readiness clause whereby you can tender without free critique or not, but it's only if free critique is declined that time stops. You have to look at the issues, but again, a charterer is looking for all ways he can to make sure that time is not running. where of course the owner wants the contrary. Final topic now is force majeure clauses. These are really found in voyage charters rather than time charters, albeit not exclusively. As COVID has hit, you see voyage charterers quite frequently declare force majeure, even at a very early stage before the vessels even arrive sometimes. Sometimes it's just laying down a marker. They're worried that the vessel is going to be delayed for whatever reason. So they look through the charter, declare force majeure. It's a phrase that's bandied around quite a lot without people really knowing what it means in practice. So you have to look at your charter party. But sometimes they use it as an excuse to avoid responsibility for delays, or in rare cases, they're unable to provide a cargo and they use it as an attempt to terminate. Whether it is due to force majeure due to COVID depends on the clause, and those clauses can differ quite extensively. So you have to look at the particular clauses. But what I'm going to do is run through the main elements of a force majeure clause and the force majeure events, which could, in theory, be relevant where it's COVID-related issues. Often specified are disease, epidemics, and quarantine, obviously very relevant in the COVID era. Other common force majeure events are government restrictions. That might include restriction in port working hours, curfews, restriction on the number of gangs that can work a vessel at any one time because the port wants to limit the number of people coming into and out of the port even. Or there are delays in trucks coming into the port with the cargo, or rail bringing cargo because they're not running as much, or there's a reduced number of trains running. They can all potentially fall within that. Most clauses also require that the force majeure event, whatever that may be, impacts in some way on the working of the vessel or the provision of cargo. And it also goes on to specify the type of impact that will have. For example, does the working of the vessel or the provision of cargo merely have to be prevented, or can it be a bit less? It can be delay or hindered. So I'll give you an example here. Force majeure clause. You're at the port. The port imposes restrictions on the working hours and the number of stevedores allowed to work. As a result of that, for example, you might only work 9 till 6 rather than 24/7. Or you may only be allowed 1 or 2 stevedore gangs to work at any one time when you might have had 3 normally. The net effect of that is that the load and discharge is reduced, and it's going to take longer to finish cargo operations. And the charterers declare force majeure and rely on the government restrictions force majeure event in the charter. Now, as to whether or not that applies, you have to look at what the wording of the clause. The charter will say, when the hours that the port is, it's preventing me from loading force majeure. The owner will say, well, no, it's not preventing loading or discharge, it's just delaying it because you have to wait a few hours. So there's a dispute as to the extent to which time actually counts. Excuse me. Also, disputes are lack of cargo. The charterer might rely on the force majeure clause because he hasn't got the cargo. But you then get disputes as to, well, is it the cargo merely delayed, or doesn't he not have any cargo at all? And in either case, what is the reason for that lack of cargo? Why is it? Is it COVID-related issues, legitimately? And is it beyond the charterer's control, or is it just because, his cargo sales fallen through and so he hasn't got the cargo and it's nothing to do with COVID? So you get a lot of disputes like this. And that is pretty much a quick counter through of the various disputes that we have. So let the arbitrations begin, and over to you, LMAA, and the arbitrators. That's it from me.
Well, thank you very much, Andrea. Yes, I'm sure my colleagues are and I are all rubbing our hands, looking forward to all these problems, many of which, of course, were anticipated. But you're right, we have not seen so many to date, but they're probably coming along the road. So there we are. Thank you. 3 excellent presentations. The chat facility has not attracted as much interest as we might have hoped for. I'm just trying to get my thing into a view where I can see it. Now, the Thai prize has attracted the greatest interest, but that doesn't mean that only Daryl has to comment. But one of the points that's been raised comes from Ian Gaunt, who says, as it's extremely difficult to prove the defense of inherent vice in China, how can a ship owner protect himself or itself if the cargo is damaged by inherent vice, as understood in English law, and the deficiency of the cargo cannot be discovered without, for example, temperature or moisture measurement? That is to say, more than the master's visual inspection. Daryl, would you like to comment on that first? And then if
Sure.
either Andrea or Emmett wants to say something, we'll have them.
Yeah, absolutely. I think, firstly, if one thinks about it under a time charter, then as between the owner and the charterers, they've agreed, no doubt, an ICA, which in a sense provides an insurance solution, because the claim, the risk of cargo claims for inherent vice are generally being split 50-50 under clause 8D, unless you have an exceptional case, such as the Court of Appeal case where the vessel was held waiting off the discharge port, and you might then have an act. But generally it's a 50-50 apportionment and an insurance solution. If you're looking at a position under a voyage charter, then it seems to me the owner has accepted freight in return for taking soya beans to China. He knows that there is, nobody can not know that there's a risk when you take soya beans to China of being hit with a cargo claim for inherent vice. And it seems to me that that is part and parcel of the bargain. Of course, he can always change that bargain by putting in an express term. I suspect an express term wouldn't be acceptable to the market, because the charterers, P&I clubs, would reject anything that seeks to pass it down unless it was couched in careful terms. So I think fundamentally we have an insurance solution which runs out with the last time charter in the charter chain.
Okay, thank you. I don't know if either of our other speakers want to comment on that. If not, can I throw the latest point at you? You might not have had time to read it, from Jim Layton, who says, following on from other points, it seems that in the light of the known risks with Chinese courts, there would be a reasonable argument that we're into the territory of an implied indemnity for adverse consequences of the master signing bills of lading along the lines of the Caroline P. What do you think, Daryl?
I don't know that I can express to be familiar with the Caroline P at the moment, but we've seen recently in the SMART decision that implied terms that might have been assumed by shipping lawyers still have to undergo the critical tests set out by Lord Nuremberger in Marks and Spencer's, so subject it to the test and see whether you think you pass. I suspect it'll be quite difficult.
Thank you. Emmett, do you want to say anything about this?
I think that in relation to this question, and also Ian Gaunt's question before, I mean, part of the problem is that we're proceeding on the basis, perhaps we think absolutely rightly, that all of these decisions of the Chinese courts are just wrong. But there was another question I think was raised about jurisdiction clauses and approaches to jurisdiction, etc. but ultimately you can only go so far. Either your documentation, your bills of lading, etc., may be able to protect you to some extent. But ultimately, if by going to a place and agreeing to go to a place, you are exposing yourself to the possibility that it's the courts of that place may ultimately get involved in the shipment and make a decision adverse to you. So where you're in a situation where you have two different courts or tribunals making a decision about something that's ultimately a factual question. I mean, what was the cause of this cargo damage? What was the cargo actually in good order on shipment and damaged due to a lack of care by the vessel during the voyage, or was it pre-shipment damage or inherent vice? Well, clearly, if you have two different courts or tribunals who are in a position potentially to be deciding that question, well, there's a possibility of different answers to the question. So I think that ultimately, in the absence of some sort of special protective clause, ultimately there is a risk on the part of anyone, particularly the ship owner, who is going to a place and potentially exposing themselves to the decision of the courts of that place. So if it is a big problem, I think ultimately you're going to be in the realm of either some sort of special clause, or as Daryl has said, you're in the realm of insurance and a sort of rough and ready allocation of risk by virtue of an ICA clause. But I can't see, for my part, the English courts accepting an implied indemnity argument just because the bill of lading involves Chinese trade or the trade of any other country, but part of that is, of course, because ultimately, if a matter comes before an English court or tribunal, it may well be that court or tribunal's role is simply to make its own decision on the relevant factual questions about inherent vice and so forth. But I think going beyond that and saying that, well, we're going to take for ourselves the power to decide all of these issues and to be the ultimate arbiters to the extent of granting a general indemnity against any decision of a foreign court that we don't agree with. I don't think that that's territory that an English court would be willing to go into.
Can I just add, and I'll be very brief, two quick points. We sometimes see a clause that's called the Iraqi clause, which gives a complete indemnity to a charter if you go to Iraq and get a cargo claim. You don't have them in China. That's an indicator you're accepting the risk of going to China. Ian Gaunt said, was I right to say that the Chinese wrongfully assumed jurisdiction? Yes, of course I am, but I speak through the prism of an English lawyer. But it is a breach of the arbitration agreement. If it's a breach, that means it's wrongful. And of course, we've seen the Frio Dolphin now that you can bind the cargo underwriters into that wrongful act.
Yes, thank you. I suspect that the Iraqi clause originated from a case of mine, the name of which I cannot now recall, but it went to the Court of Appeal where it was held that there was I think it was known as the Iraqi system in respect of cargo claims, almost any cargo that was discharged.
The Island Archon.
The Island Archon, that's the one, yes. Yeah, and then there's a point which is not really a question, but a very good point, I think, made by Geoffrey Bloom, that, as he said, most voyage charters oblige the master not to add anything to original bills of lading. And so any remarks as to the quality of the cargo are forbidden. So he has to issue effectively a clean bill of lading, which even if he knows is wrong, it should be a dirty bill of lading. And this is a dilemma that masters do face from time to time. Because they're simply told, no, you can't clause the bill of lading. And then we have problems about well, we know the delay involved in dealing with that. Now, are there any other questions? I'm surprised there's nothing on the Sea Challenger. No.
I think on the clean bill of lading, of course, the master generally has to reject cargo he can't issue a clean bill for. The bill of lading must be accurate. It can't be construed as an agreement to issue an inaccurate bill of lading. So I think that's the answer.
Well, of course, quite often the cargo has been loaded and it's a bit too late, so he has to insist on it being removed, which can create its own problems.
Of course.
Well, does anybody have any other points on that they could put on the chat system? Because we really have. Yeah, thank you, Jeffrey. Darryl, you're right in theory, but never in practice.
Well, I only deal with the theory. Whilst we're waiting for any other comments, I'd maybe just pick up on the one observation that Lord Justice Mayles made about, well, if the shipper actually knew it was defective cargo, he had some sympathy, and I think I don't think the answer would be any different under the charter party, because the charterers are not necessarily the past persons with actual knowledge. The shipper is their delegate for the purposes of tendering a bill of lading. But as we know from the global Santosh, they're only the delegate to the extent that you have a contractual obligation to perform a particular duty. And the charterer, when they tender a bill of lading, has no obligation to say anything about the apparent good order and condition of the cargo at all. So if there's no obligation on him to say anything, then the shipper can never be his delegate, it seems to me.
Interesting point. Well, nothing else has popped up on the chat. So I assume that we're all content, have no more questions or comments that we want to make. I do think it's fair to comment that, as I said before, we must look forward to, I suspect, a lot of disputes arising as a result of COVID. And it was really good to hear from Andrea about the sort of things that the clubs are seeing by way of problems. And I look forward to seeing them coming to us to determine. Not going to be an easy task, I think. A question on the Sea Challenger. Does it follow from the judgment in the Sea Challenger that it will be a rare day when a charterer can say they relied on representation as to a vessel performance, if this doesn't usually include what is stated in the performance warranty itself? One for you, Emmett.
Well, I think there's it's probably a slight cop-out answer, but I think there's ultimately it'll depend on what's said. So I think there's, if a ship owner is unwise enough to make some specific factual representations about the vessel's performance in the pre-contractual negotiations, I don't think they would be protected simply by virtue of the fact that ultimately no speed and consumption warranty was agreed in the charter party, or figures were given, but they were given all details about without guarantee or something along those lines. Because ultimately, I think the law in relation to misrepresentation in this context is pretty much freestanding. So if you do have a ship owner saying, my ship is super efficient, here are the figures for recent voyages, and it turns out that the vessel actually performs very much worse than that, well, I think you still could be in the base in the circumstances of having a misrepresentation claim, even if a warranty reflecting those figures didn't find its way into the charter party. So I think the lesson from an owner's perspective is that factual statements that you're making about your vessel's performance could come back to bite you, regardless of what's ultimately agreed in the charter party. But from a charterer's perspective, unless you actually agree the warranty you want in the charter party, well, you may need to be a bit probing in what you're asking the owners via the brokers in the pre-contractual negotiations. If the current performance of the vessel is very important to you, because it may well be that if some details, vessel details arrive just stating boldly some speed and consumption figures, if the matter ultimately went to arbitration or to court, the court tribunal might decide that those figures at the just vessel details, well, it's also vague as to what's actually being said. I mean, what's being said, these could even be original figures, you know, as designed performance figures, rather than figures for necessarily figures for the vessel's current speed and consumption. So from a charterer's perspective, I think, you know, I would be looking to try and get a bit more clarity about what's actually being said. But on the particular question asked, no, I think that even if there isn't a warranty, the pre-contractual representations, if there are some clear representations, could still be relevant and could found a claim, even if a warranty doesn't find its way into the charter party.
But if there are warranties in the normal way, what would then be the effect on anything that might have been said before the charter party was concluded? Would it have any relevance?
Well, I think that you would be in there potentially some difficult questions. I mean, if what found its way into the charter party was pretty much just reflected the figures that had been put forward in pre-contractual discussions, well, then I think the charterer is highly likely just to be relying on the breach of warranty, albeit there may be a rare case where the difference between the warranted and represented performance on this particular hypothetical scenario and what the vessel actually achieves is so great that the charterer might want to get out of the contract entirely. And there was one case in which that was successfully done. And if you were in that scenario, you might want to be running both. You might want to be saying that the speed and consumption is so grossly below the warranted performance that amounts to a repudiatory breach. And also that we would never have entered into this contract in the first place if it hadn't been for your factual representations about the vessel's performance. So regardless of the repudiatory breach analysis, we're entitled to rescind for misrepresentation. But I think you'd potentially have some really difficult questions if there was a sort of mismatch. So you had X being represented as the actual current performance of the vessel factually in the pre-contractual discussions, but then something different finds its way into the charter. I think you'd have difficult questions of inducement, etc. Then that might take a bit of teasing out, and I suspect would be very heavily fact dependent.
Yeah, thank you very much. Well, nothing else has popped into the chat box at the moment except that a Supreme Court's decision on an application for permission to appeal in the tie prize is awaited. So unless anybody has anything else, I'm proposing to wind up this session. Thank you all very much for coming.